What was the case all about? The family of Henry and William Goleknath held over 500 acres of farmland in Jalandhar, Punjab. In the phrase of 1953 Punjab Security and Land Tenure Act, the state government held that the brothers could only keep 30 acres of land each. This was challenged by the Golaknath family in the courts, and the case was referred to the Supreme Court in 1965. The family filed a petition under the Article 32 challenging the 1953 Punjab Act on the grounds that it denied them their constitutional rights of acquiring and holding the property and practice any professions, Article 19(1)(f) and Article 19(1)(g), and to equality before and equal protection of laws, Article 14. They also sought to have the 17th Amendment, which had placed the Punjab Act in the 9th schedules of Indian Constitution.
Greetings to respected ma'am and fellow companions. Now we are representing a virtual moot court in front of you with the sheer teamwork of Neerav Madan enacting as Honorable Justice K.N. Wangchu, Ketan Bhardwaj as Henry Golaknath, Utkarsh Kumar as Chief Minister of Punjab, Alaina Robert as lawyer, Roy Peters as William Golaknath, and Hansin Kapoor as Mr. M.K. Nambiar. All raised for Honorable Justice.
Yes, now you may proceed with the case.
My lord, my clients Mr. Henry and William Golaknath had 500 acres of land in Jalandhar district of Punjab. Now, sir, due to 1953's Punjab Security and Land Tenures Act, which states that every landowner or tenant who owns or holds land in excess of the permissible area and where land is situated in more than one patwar circle shall furnish within a period of 6 months from the commencement of the Punjab Security of Land Tenures.
Have you submitted the material for that too in the brief?
Yes, sir, I have submitted a detailed paperwork on this too.
Okay, you may proceed.
Sure, my lord. Now my clients have filed a petition in the Honorable Court challenging the Punjab Security and Land Tenures Act on the ground that it has denied them their constitutional rights to acquire and hold property and practice any profession and to equality before and equal protection of law under Article 32, Article 19, Part 1, subclauses F and G, and Article 14 of the Indian Constitution.
Okay, now Mrs. Sushmita, you may speak.
Yes, my lord. My lord, as being a state prosecutor on behalf of the government of Punjab, I would like to first take your attention towards the Punjab Tenures Act, as said by Mrs. Nambiar, that if a law has been made, then everyone has to abide it, whether a person has ample of something or not. The Punjab Act has also been added in 9th schedule of the Indian Constitution to with the 17th Amendment as per being made by legislative statutes. Sir, now we must strictly adhere to the norms of regulations made by the Parliament. Thus, by giving rest of the 440 acres of surplus land to the government of Punjab would help in the state development and would also benefit society by an equal and just distribution of land. By giving it to minority groups who want to settle by obtaining the land, the government will be responsible for making hospitals, setting up industries, and might give land to small landowners as making them self-reliant and independent.
Okay, now Mr. Nambiar, you may contradict by presenting evidence from your client's side, if you have any.
Sure, sir. My lord, may I ask a few questions from Mr. Golaknath?
Sure, permission granted. You may proceed.
So, Mr. Golaknath, you have filed a petition against the Punjab government regarding a 500-acre land which was being taken over for public good. Is that true?
Yes, sir. As stated earlier, a right over a land which we inherited from my father was being curtailed by the government of Punjab over a baseless act passed in 1953. Also, sir, how come the government can use our inherited property for public good, as we too have right to freedom as per the fundamental rights on our property. Thus, it seems like we don't have any right on our own property legally.
Objection, my lord.
Yes, madam. Objection granted. Please proceed.
My lord, for doing several public welfare activities for the state's own citizens. Now, in today's time, the government has to ask people to use up their own state's land. How can you think of claiming the land yours? It's the government's land and it can be used for any purpose it thinks of using it, moreover, benefiting the society.
Objection, my lord.
Objection granted. You may proceed.
Madam, trying to acquire the land of my clients using such baseless and unfundamental laws isn't judicially justified. Laws and acts are, as per the legislative statutes, are made on public interest, and when the citizens used to think their rights are being infringed, they used to move to the court for a just trial. And if we, as social builders, will deny justice to them, not giving them right to neither use their land properly, nor letting them settling down on it, I will see this as a failure to the fundamental rights, the Constitution, and the constituted elected body, the Parliament.
Sir, are you trying to say that what all governments do is not done for the society? What is the rationale for making a democratically elected government then? We spend day and night so that we can fulfill the needs of the citizens, develop our state and whatnot. If that's the case, then this might be a disgrace to our principles.
Please come in the witness box and then speak to Mr. Kish.
My lord, referring to the needs of the minorities, backward communities who are economically and socially weak, we try to develop a gracious infrastructure for that purpose.
Objection, my lord.
Yes, Mr. Nambiar. Objection granted.
My lord, can the honorable representative of the state government of Punjab, Mr. Ram Kishan, tell me, by keeping aside his designation and as being a normal law-abiding citizen of the country India, what will happen to you when the land which you own, to which you have all legal rights as per the boards and all sections of the law, you must have planned and in expanding the area of your dreams, and then suddenly an old criteria passed years ago drastically fall into it, thus leaving you with restrictions of thoughts, opinions, and expressions. You can also not choose a choiceable and a professional propaganda for yourself. What type of fundamental right you have been provided with from the Indian Constitution then? When such a freedom isn't there, it's an unfair overruling of the very doctrine of the basic structure of the Indian Constitution, the right to freedom.
The case further moves to the High Court of Punjab and Haryana. As per the judicial review, the petitioners are Henry Golaknath's son, grandson, and granddaughters, and respondents are the state government of Punjab. Case is headed by Honorable Justice J.C. Shah. All rise for Honorable Justice J.C. Shah.
Yes, please proceed now.
Sure, my lord. My lord, as we all know that the Constitution of India was drafted by the Constituent Assembly and it is of permanent nature. Thus, no one can change or can try to bring a change in the Constitution of India. The word amendment in question only implies a change in accordance with the basic structure, but not altogether a whole constitution. My lord, I would like to emphasize on how it should not be amended to the extent where it tampers with its fundamental characteristic.
Objection, my lord.
Objection granted. Please proceed.
I contend before the court that the constitutional amendment is a result of the exercise of its sovereign power. This exercise of sovereign power is different from the legislative power which Parliament exercises to make the laws. The object of amendment as given in the Constitution is to let the Parliament amend the Constitution according to the will of the people and changing scenarios in the country.
Objection, my lord.
Objection granted. Please proceed, Mr. Nambiar.
Sir, I contend that fundamental rights inscribed in Part 3 of the Indian Constitution are integral to the Constitution. Hence, they form an essential part of the Constitution. In absence of these rights, the Constitution is like a body without its soul. Now, the word amend has limited meaning under Article 368 of the Indian Constitution. Article 368 provides a procedure for amendment in the Constitution, and it does not mention the power to the Parliament to make an amendment to the Indian Constitution. Also, the interpretation of the word amendment as it implies for a change in tune with the basic structure of the Indian Constitution.
Objection, my lord.
Please proceed.
Sir, the concept of a basic and non-basic features of the Constitution believed everything in the Constitution to be basic, and further that it could be amended for the growth and progress of the country. The absence of amendment provisions from the Constitution would make it extremely rigid. I disregard inequality between different provisions of the Constitution and state that all the provisions are equal with no underlying hierarchy. A lot of the amendments were made out of political necessity. They ought to be out of the limit of judicial jurisdiction.
The case further moves to the Supreme Court of India as per the appellate jurisdiction of the court for the judicial review again. The decision made by the Honorable Supreme Court by heated argument between Mr. Nambyar and Ms. Susmita Rao, the Supreme Court held an 11 bench of judges for critically analyzing the case and passing the judgment that made it historic.
My lord, I contend that the meaning of law under Article 13, Part 3 of the Indian Constitution includes every branch of law. Therefore, by the application of Article 13, Part 2, which reads as follows, the state shall not make any law which takes away or abrogates the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. The state cannot make laws that strip the citizens of their fundamental rights, and such laws would deem to be void.
My lord, to enforce directive principles of the state, the Constitution has been amended many times. Hence, the reversal of the previous decisions would introduce disturbance and create havoc in the country. Rest I end my statement here.
Fundamental rights are considered necessary for the development of human dignity. These are the rights that help a man to see his health the way he wants. Our Constitution has given us fundamental rights, including the rights of minorities and other communities that we are lagging behind. According to the Constitution, the Parliament and the provincial legislatures of India have the power to make laws in their respective constituencies. However, this force is completely absent from nature. The Constitution rests with the judiciary, and the power to adjudicate the legitimacy of all constitutional laws rests with the judiciary. If a law made by Parliament or the legislature of a country violates any provision of the Constitution, the Supreme Court has the power to declare that law invalid and unconstitutional or ultra vires. This experiment, however, the founders wanted the Constitution to be a flexible document rather than a solid document that could adapt to changing circumstances.
Article 368, Part 1 of the Indian Constitution grants constituent powers to make formal amendments and empowers the Parliament to amend the Constitution by the way of addition, variation, or repeal of any provision according to the procedure laid down therein, which is different from the procedure for ordinary legislation.
Judgment. In this case, at that time, the Supreme Court had the largest bench ever. The ratio of the judgment was 6:5, and majority was favoring the petitioners. The majority opinion of Golaknath shows skepticism in their minds about the Parliament. Since 1950, the Parliament has used Article 368 and have passed a number of legislations that had, in one or the other way, have violated the fundamental rights under Part 3 of the Indian Constitution. The majority had doubts that if a time can come when all fundamental rights adopted by our Constituent Assembly will be changed through amendments, fearing that there can be a transfer of democratic India into a totalitarian India. The judgment came that Parliament has no right to amend the fundamental rights. To save the democracy from an autocratic actions of the Parliament, the majority held that the Parliament cannot amend the fundamental rights enshrined under Part 3 of the Indian Constitution. The majority said that fundamental rights are the same as natural rights, and these rights are important for the growth and development of a human being. Now here I have given a brief on the analysis of the judgment. This judgment helped to stop the Parliament from showing its autocracy. This judgment forbade the Parliament from causing any damage to the fundamental rights of the citizens by implementing a law which had the effect of suppressing the autocracy of the Parliament. The judgment was focused on protecting the fundamental provisions which are equal to fundamental or natural rights of the mankind, and no government can take it. This case reinforced the faith of the citizens that the law is supreme, not the one who makes it, neither who implements it, and not the one who interprets it.
The Supreme Court in the well-known Golaknath's case reversed by a narrow majority its own earlier decisions, upholding the power of Parliament to amend all parts of the Constitution, including Part 3 relating to fundamental rights. The result of the judgment is that the Parliament is considered to have no power to take away or curtail any of the fundamental rights guaranteed by Part 3 of the Constitution, even if it becomes necessary to do so for giving effect to the directive principles of state policy and for the attainment of the objectives set out in the preamble to the Constitution. It is therefore considered necessary to provide expressly that Parliament has power to amend any provision of the Constitution so as to include the provisions of Part 3 within the scope of the amending power. The bill seeks to amend Article 368 suitably for the purpose and makes it clear that Article 368 provides for an amendment of the Constitution as well procedure therefore. The bill further provides that when a Constitution amendment bill passed by both Houses of Parliament is presented to the President for his assent, he should give his assent thereto. The bill also seeks to amend Article 13 of the Constitution to make it inapplicable to any amendment of the Constitution under Article 368.
The bill was considered by the Lok Sabha on 3rd and 4 August 1971 and passed in the original form on 4 August 1971. While moving the bill for consideration in the Lok Sabha, H.R. Gokhale stated that the fear that Parliament would misuse the power to curtail fundamental rights once it acquired the power to amend them was unfounded. Gokhale further stated that directive principles must prevail over fundamental rights. In response to critics of the amendment, Prime Minister Indira Gandhi stated, "We are committed to the upholding of the fundamental freedom of assembly and of worship, and our commitment to secular democracy is non-negotiable." The bill was passed by the Lok Sabha, was considered by the Rajya Sabha on 10 and 11 August and passed in on 11 August 1971. The debate in the Rajya Sabha was brief.
The 24th Amendment was effected to abrogate the Supreme Court ruling in Golaknath versus State of Punjab. The Supreme Court delivered its ruling by a majority of 6 to 5 on 27th February 1967. The court held that an amendment of the Constitution is a legislative process and that an amendment under Article 368 is law within the meaning of Article 13 of the Constitution, and therefore it is if an amendment takes away or abridges a fundamental right conferred by Part 3, it is void.
Article 13 reads that the state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. The court also ruled that the fundamental rights included in Part 3 of the Constitution are given a transcendental position under the Constitution and are kept beyond the reach of Parliament.
The court also held that the scheme of the Constitution and the nature of the freedoms it granted incapacitated Parliament from modifying, restricting, or impairing fundamental freedoms. In Part 3, the judgment reversed the Supreme Court's earlier decision, which has upheld Parliament power to amend all parts of the Constitution, including Part 3 related to fundamental rights.
The judgment left Parliament with no power to curtail fundamental rights. To abrogate the ruling, the government intended to amend Article 368 to provide expressly that Parliament has power to amend any provision of the Constitution, thereby bringing fundamental rights within the scope of its amending procedure.